and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court agreed to consider listing urgently the matter concerning the hijab ban in the state of Karnataka. Senior Advocate Meenakshi Arora mentioned before the court that urgent interim directions are required to permit Muslim students to appear for exam which will be conducted in government colleges only. She submitted that the students have already lost one academic year and that as they have to switch to private institutions after Karnataka government banned entry with hijab. Bench headed by CJI Chandrachud to this assured that the matter will be listed before a third bench. In October 2022, in appeal against Karnataka High Court judgment allowing the government decision to ban hijab in educational institutions, two-judge Supreme Court bench has delivered a split verdict. While Justice Hemant Gupta held that hijab ban decision, Justice Sudhanshu Dhulia ruled against the same as arbitrary and unconstitutional. While the former rejected appeal for protection under the purview of Constitution, the latter was of the view that asking pre-university schoolgirls to take off their hijab at the university gate is an invasion of her privacy and dignity. Justice Dhulia opined that the same is clearly violative of fundamental rights given to her under Article 19(1)(a) and 21 of the Constitution of India. The Supreme Court has refused to entertain petitions seeking directions to make available answer sheets of all the candidates who appeared for the mains written examination for District Judiciary in Madhya Pradesh under Right to Information Act. The three-judge bench of Justice CJI Chandrachud, Justice V. Subramanian and Justice J.B. Pardiwala observed that the proportion forwarded by the petitioner was extremely dangerous and prone to misuse as coaching institutes can get hold of the same. The petitioner, an organization named Advocates Union for Democracy and Social Justice, had approached the Madhya Pradesh High Court with contention that disclosing the answer sheet would help the future aspirants. It was further contended that for achieving the ultimate goal of transparency in the process of selection and appointment to the post of civil judge entry level and district judge entry level in the state, the answer copies written by the candidates ought to be made available on the website of the court. The court, however, held that the information sought by the petitioner is barred under Section 8 of the Right to Information Act as the answer sheets are held in exercise of fiduciary relationship between the candidate and the concerned authorities. On similar note, the Supreme Court has held that the copies of charge sheet and the relevant documents along with the charge sheet do not fall within the ambit of Section 4(1)(b) of the Right to Information Act. It was also held that if charge sheet and relevant documents produced along with the charge sheet are put to the public domain or the website of the state government, it would be contrary to the schemes of Criminal Procedure Code and it may also violate the rights of the accused, victim or investigating agency. The bench expounded that the charge sheet and the documents along with the charge sheet cannot be said to be public documents under Section 74 of the Indian Evidence Act 1872. The Supreme Court has reiterated that the process of criminal law cannot be utilized for arm twisting and money recovery, particularly while opposing the prayer of the bail. The division bench of Justice Dinesh Maheshwari and Justice Harishikesh Roy was of the view that in a given case, the concession of pre-arrest bail or regular bail could be declined even if the accused has made payment of the money involved or offers to make any payment. Conversely, in a given case, the concession of pre-arrest bail or regular bail could be granted irrespective of any payment or offer of payment. Noting that recovery of money is essentially within the realm of civil proceedings, the court emphasized that ordinarily there is no justification in adopting such a course that for the purpose of being given the concession of pre-arrest bail, the person apprehending arrest ought to be make payment. A division bench of Justice S. Ravindra Bhatt and Justice P.S. Narasimha of the Apex Court has held that conviction cannot be done solely based on the last seen theory. It was further observed that a basic principle of criminal jurisprudence is that in circumstantial evidence cases, the prosecution is obliged to prove each circumstances beyond a reasonable doubt as well as the link between all the circumstances. Such circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused and none else. Another division bench of Justice M.R. Shah and Justice C.T. Ravikumar has held that the amount of royalty cannot be mixed with the compensation or loss caused due to the state government due to loss of land and surface rent, as the state government is entitled to the adequate compensation. It was expounded that the compensation or rental payable is different from royalty. Royalty is for the extraction of minerals in the lands in question. Therefore, the coal company or government company shall be liable to pay compensation and surface land rent, etc. over and above the royalty. Next we have Delhi High Court. The Delhi High Court has issued a set of 11-point guidelines to shield survivors under the Protection of Criminal from Sexual Offences Act who have to physically appear in court during arguments on bail and face the accused. The single-judge bench said that the psychological impact on a POCSO survivor being present in a court during the arguments is grave, as there are allegations, accusations and aspersions on the integrity and character of the prosecutrix and her family. The Delhi High Court has asked the centre to ensure within 6 months the enforcement of legal provisions pertaining to the grant of compensation to victims of road accidents caused by the uninsured vehicle, as well as in case of hit and run. The central government told the court that it has amended the law pertaining to the motor vehicle to grant compensation in case of accidents caused by uninsured vehicle, but guidelines were yet to be framed. It said now a scheme is in place for granting compensation to road accident victims even if the accident causing vehicle is uninsured, and urged the court to give it a breathing time of 6 months to implement the changes throughout the country. The Delhi High Court has refused to restrain for the time being the sale of sandwiches under the name Suburb by a city-based outlet and observed that global restaurant chain Subway could not claim monopoly over all two-syllable words. Justice C. Hari Shankar, while dealing with the lawsuit filed by Subway, observed that Subway and Suburb, when used in context of eateries serving submarine sandwiches, were not deceptively similar, and their lettering, font, appearances were also easily distinguishable from each other. Noting that Law Intern is a student who is in process of understanding the practice and procedure of the court, the Delhi High Court quashed FIR against one such intern who appeared before a district court as a proxy counsel for a lawyer and sought adjournment in a case. The single-judge bench of Justice Anish Dayal was of the view that instead of punishing at the first instance, it is the duty of the institution to take adequate steps to facilitate their education and training and not simply punish them for such inadvertent acts. The FIR was registered on a complaint filed by Secretary of the Dwarka Court Bar Association Jitendra Solanki after Principal District and Session Judge declined to take any legal action in the matter. It was a contention of the Secretary that there were many such cases of interns appearing before the courts, and the presiding officer of these courts had forwarded complaints to the Bar Association. However, Justice Dayal opined that the present matter has been blown out of the proportion, particularly as the petitioner didn't attempt to trick the court and admitted to the fact that he is an intern and also produced ID when asked. Now let's have an overview of other high courts. The Kerala High Court, in view of increasing number of cases of sexual harassment involving students, particularly within the campuses of educational institutions, has observed that lessons in good behavior and etiquettes must be part of the curriculum. And from at least the primary class level, teachers must be encouraged to instill virtues and values in the students. The single-judge bench of Justice Diwan Ramachandran remarked that sexism is not acceptable or cool, and one exhibits strength when he respects a woman or a girl. Respectfulness is an imperative and that needs to be inculcated at very young age. How one treats a woman gives an insight of his upbringing and personality, the court stressed. The court, while adjudicating upon a petition filed by a student challenging the order of the Internal Complaints Committee and the order passed by the principal of a college, remarked that increasing instances of sexual harassment against students, even in the school and colleges, impel us as a society to think and introspect very closely. The Guwahati High Court has expounded that medical treatment is a fundamental right as envisaged in Article 21 of the Constitution of India, but such right cannot be interpreted and extended to a person treated in a private hospital of his or her own choice, while such kind of treatment is very much available in the government hospital. The Himachal Pradesh High Court has clarified that there is no bar on an additional district and sessions judge to sit at any place other than his court premises within his sessions division to record evidence and conduct a trial. The single-judge bench of Justice Satyendra Vaidya was entertaining a written request from learned additional district and sessions judge seeking permission to visit the place of accused to conduct trial before it, as the accused was bedridden owing to fracture. He stated there is no such permission is required, and as Section 9 of the Code of Criminal Procedure authorizes the learned judge to do so. The Punjab and Haryana High Court has observed that a person seeking to establish his adverse position must show that his position was adequate in continuity, in public, and in an extent to show that their position was adverse to the true honour. Moreover, it must start with a wrongful disposition of the rightful honour and be actual, visible, exclusive, hostile and continued over the statutory period. The Patna High Court has observed that father-in-law shall be under no obligation to maintain his daughter-in-law except in cases where there is some ancestral property in his possession from which the daughter-in-law has not obtained any share. It clarified that the object of Section 19 of the Hindu Adoption and Maintenance Act 1956 makes it clear that the widowed daughter-in-law can claim maintenance from her father-in-law only where she is unable to maintain herself out of her own property or from estate of her husband, father, mother, son or daughter. The court further affirmed that the obligation of father-in-law shall not be enforced if he has no means to maintain his daughter-in-law from any co-parental property in his possession out of which the daughter-in-law has not obtained any share, and any such obligation ceases on the remarriage of the daughter-in-law. Moving on to miscellaneous news. The Chief Justice of India, CJI Chandrachud, has inaugurated a software that will allow e-inspection of digitized judicial files of the Delhi High Court. The CJI, in his address, said that the Delhi High Court has always been at the forefront of changes in judiciary, and the Supreme Court tends to follow the facilities it introduces in its premises. The online e-inspection software will facilitate online e-inspection of digitized judicial files through the internet at the click of a mouse from the comfort of homes or offices or of advocates and litigants. The Supreme Court has agreed to consider amending the guidelines of executing a living will, which is an advanced medical directive by a person about what treatment he or she would like or not to avail at the end of their life, including to do away with the requirement of seeking the jurisdictional magistrate's approval for withdrawing or withholding life support to the terminally ill. A 5-judge constitution bench headed by Justice K.M. Joseph said that the guidelines could reflect that the witness and notary record the satisfaction that the document has been executed voluntarily and without any coercion or inducement or compulsion, and with full understanding of all the relevant information and consequences. Amid the battle between executive and judiciary over judicial appointments, Union Law Minister Kiran Rijiju has said that it is a matter of grave concern that the Supreme Court Collegium put a certain portion of sensitive information of the Intelligence Bureau and the Research and Analysis Wing in public domain. Intelligence agency officials who work in a secret manner will think twice if their reports are made public, Mr. Rijiju said. The Supreme Court Judge Justice Sanjay Kishan Kaul, while flagging the issue of huge pendency of cases, also pointed out the fact that 33% cases coming to the Supreme Court are bail application, which calls for introspection. The NALSA Executive Chairperson, Justice Kaul, made the comment on inaugural function of First Region Conference for the year 2023, wherein he said that it will take some kind of revolution or an out-of-the-box thinking to dispose of all the pending cases on bail and remission. As for judiciary to do it in the normal course will take 700 or more years. The Supreme Court has dismissed a petition questioning validity of the Union Government's decision of October 2022 to set up a panel to examine scheduled caste status for Dalits who converted to Christianity or Islam. In October 2022, the Centre has appointed a commission for inquiry under the chairmanship of former Chief Justice of India, K.G. Balakrishnan, to examine claims of granting scheduled caste status to the Dalits who have converted to other religions. The commission, also comprising retired IAS officer Dr. Ravindra Kumar Jain, former member UGC Professor Sushma Yadav as members, was given the mandate to examine the matter for according SC status to new persons who claim to have belonged to the SCs historically but have converted to the religion other than those mentioned in the presidential order issued from time to time under Article 341 of the Constitution. The centre government has made it mandatory for social media influencers and celebrities to disclose their material connection or interests such as shares in the company, employment or self or family, gift, free trips, hotel accommodations, discounts and awards while endorsing any product, service or brand. Violation of this will attract a fine of up to Rs 10 lakh for each offence and up to Rs 50 lakh for repeat offence. The guidelines titled Endorsements Know-Hows, released by the Consumer Affairs Ministry, also said that the disclosure of all the forms of social media has to be hard to miss, which means these have to be displayed prominently and in a manner that none can miss them while reading, listening or seeing such endorsements. The Supreme Court has refused to entertain a public interest litigation seeking enforcement of one car, one pension norm, besides demanding imposition of environmental tax on every second vehicle, stating that these are policy issues on which courts cannot intervene. The PIL filed by Tsunami on Roads, a non-governmental organization, has stated that the burgeoning volume of vehicles on road was creating a huge environmental crisis and suggested that limiting the number of cars and that can be brought by an individual and imposing environmental tax will help keep vehicular pollution in check. In the end, we have international news. Meta's subsidiary WhatsApp was fined €5.5 million by Ireland's Data Privacy Commissioner (DPC) for an additional breach of the EU's privacy laws. The DPC, which acts as the EU's lead privacy regulator for Meta, said that WhatsApp must reassess how it uses personal data for service improvements. Its ruling follows a similar order it issued this month to Meta's other main platforms, Facebook and Instagram, which stated that Meta must reassess the legal basis upon which it targets advertising through the use of personal data. Hindenburg Research, which made big headlines here in India this week, has said that it will demand documents in legal discovery process if Adani Group files a lawsuit in the United States against the short seller for its report on the Indian conglomerate. The research group has filed serious allegations of stock manipulation and other financial irregularities in what the report has claimed to be the biggest corporate fraud in history. In response, Adani Group is planning to sue the organization in US and Indian courts over its malicious and misleading report. Lawyers have said that they expect the UK government's planned laws on enforcing minimum services levels during strikes to be hampered by legal challenges. Union could be sued if basic services are not provided in key sectors under the proposed anti-strike laws. Some unions have threatened legal actions and said that they believe that the strike restrictions would be unlawful. Europe's top human rights court has ruled that it can adjudicate on cases brought by Netherlands and Ukraine against Russia for alleged rights violation in eastern Ukraine in 2014, including downing of Malaysia Airlines flight MH17. The ruling of the Strasbourg-based European Court of Human Rights marks significant progress in efforts by Ukraine to hold Russia legally accountable. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.